Hello, my name is Noor Nabila, and today I will be presenting natural law. Natural law is a philosophy that asserts certain rights and moral values are inherent in human nature and universally recognizable through reason. This legal theory posits that these laws are innate and can be discovered through rational thought without the need for written statutes or legislative enactments. The concept of natural law has deep historical roots, tracing back to ancient civilizations and philosophical traditions. In ancient Greece, Aristotle argued that natural law was the basis for human conduct, aligned with the rational order of the cosmos. During the Roman period, Cicero believed that the true law is universal, eternal, and based on reason, transcending local customs. In the medieval period, Thomas Aquinas further developed natural law theory, integrating Christian theology with Aristotelian philosophy, and Aquinas argued that natural law is part of God's eternal law, accessible to human reason. During the Renaissance, thinkers like Hugo Grotius and John Locke emphasized natural rights derived from natural law, influencing modern democratic societies. And in the modern era, John Finnis has revitalized natural law theory, arguing for its relevance in contemporary moral and legal debates. Natural law significantly contributes to our understanding of law by suggesting that legal systems should reflect inherent moral principles and human nature. It emphasizes that justice, ethics, and human rights are foundational to any legal framework. And according to natural law, valid laws align with these moral principles, and unjust laws are not true laws at all. Natural law has also profoundly influenced society and the judiciary, particularly in shaping constitutional law and human rights legislation. Many modern legal frameworks incorporate principles of natural law, ensuring that laws promote justice and protect individual rights. Judicial decisions are often guided by these principles, reinforcing the idea that the law should serve as a moral guide for society. Thank you.
Hello, I'm Samafat, so I'm going to present on legal positivism. Legal positivism is a theory in jurisprudence that defines law as a set of rules and norms created by legitimate authority. Unlike natural law theory, which links law with morality, legal positivism asserts that the validity of a law depends on its sources and adherence to procedures, not its moral content. So John Austin's command theory views laws as commands from a sovereign backed by sanction, emphasizing the authoritative nature of law. H.L.A. Hart's rule of recognition identifies the sources of law and provides criteria for legal validity, stressing the importance of rules being accepted and followed by officials and citizens. So legal positivism frames law as a coherent system established by legitimate authorities, highlighting the importance of legal processes and structures. This perspective ensures that legal standards are clear, guiding behavior and resolving disputes effectively. So a key tenet of legal positivism is the separation of law and morality, allowing for an objective understanding of legal systems based on origins, structures, and procedures. This approach emphasizes legal certainty and predictability, essential for a stable society. Clear, publicized, and stable laws enable individuals to understand and comply with them, fostering confidence in personal and business planning. Under legal positivism, the judiciary's role is to interpret and apply existing law, not to create new ones or impose personal moral judgments. This promotes judicial restraints, ensuring laws are applied consistently and impartially, reinforcing the rule of law and maintaining the legal system integrity. Thank you. Okay, so let's go to legal realism. So legal realism is a perspective in jurisprudence that emphasizes the influence of social, economic, and political factors on the law. Unlike formalism, which views law as a set of abstract rules, legal realism argues that law cannot be understood without considering its real-world context. It posits that judges' decisions are influenced by their personal experience and societal factors, and that legal outcomes are shaped by how rules are applied in practice. So, the key figures in legal realism include Oliver Wendell Holmes Jr. and Carl Lewin. So Holmes criticized formalism, suggesting that law should be viewed through its practical effects, introducing the Batman perspective. Lewin advocated for a pragmatic approach, emphasizing empirical research and understanding law in action. So, legal realism contributes to our understanding of law by highlighting the impact of social, economic, and political conditions on legal systems. It challenges the notion that law is autonomous and emphasizes that legal decisions reflect prevailing societal conditions. Legal realism critiques formalism, stressing that law should be evaluated based on its real-world impacts. The impact of legal realism on society and the judiciary is significant. It recognizes judicial discretion and the influence of personal biases, promoting transparency and fairness in legal outcomes. Legal realism encourages empirical research and interdisciplinary approaches, integrating insights from sociology, psychology, and economics to create a more comprehensive understanding of the law. This approach helps the legal system address complex real-world issues more effectively. So that's all from me. Thank you so much.
My name is Nil Nabil and I will be presenting about critical legal studies. So critical legal studies is a legal theory that analyzes law as a social construct influenced by power structures, social norm, and historical context. It seeks to uncover hidden bias, inequalities, injustice within the legal system, and challenging the notion of law as neutral and objective. Critical legal studies challenges traditional legal approach in several key ways. Firstly is critique of formalism. CLS says legal reasoning isn't purely objective but can hide bias and uphold the status quo. Second is power and ideology. It emphasizes how power and ideology shape the law, often favoring powerful groups. Thirdly is interdisciplinary approach. CLS draws from various fields to understand how law mirrors and reinforce social inequalities. Next is legal indeterminacy. It questions the idea that legal dispute always have clear solutions, suggesting law can be interpreted differently. Lastly is emancipatory potential. Despite criticism, CLS sees law as a tool for social change, aiming for a fairer society. Overall, CLS advocates for a more critical and socially aware approach to legal scholarship and practice, seeking to disrupt conventional understanding of law and legal reasoning. There are few influential scholars within the critical legal studies movement. One of it is Duncan Kennedy. Duncan Kennedy is an important figure in critical legal studies, especially known for his role at Harvard Law School. He's known for exploring how law and power are connected, showing that legal system often benefit those in power. His book, A Critique of Adjudication, is a significant text in CLS. Other than that, we can see is Roberta Unger, Catherine McKinnon, and Meg Tashnet. Within critical legal studies, one of the significant contributions to understanding law is the recognition of law as a tool of power and oppression. CRS scholars argue that the law is not neutral or objective, but rather reflects and perpetuates existing power structures and social inequalities. There are four ways how CRS contributes to this understanding, which are unveiling hidden power dynamics, critique of legal formalism, examining law's role in reproducing inequality, and empowering marginalized voices. Overall, CLS contribution to understanding law as a tool of power and oppression underscores the importance of critically examining the social and political dimension of legal system. Within critical legal studies, there are notable impact on society and the judiciary, including advocacy for social justice and reform, as well as the examination of the role and ideology in judicial decision. Firstly, is advocating for fairness. CLS scholars and activists work to make the legal system fairer. And lastly is understanding judicial decisions. As CLS has looked into how judges' belief affect their rulings. They say judges don't follow the law, but also their own belief and bias. That's all from me. Thank you.
Hello everyone, my name is Atan Shahira. Today, I'm going to talk about the feminist legal theory, a perspective that offers profound insight into understanding of law, society, and the rules of judiciary within the legal system. So, feminist legal theory emerged in 1960 and 1970, challenged the male-centered nature of law and the legal institutions. Its critique the assumed naturality of law, arguing that they reflect and perpetuate patriarchal value and the subordinations of men. So this legal theory aims to expose and dismantle gender bias and inequalities in legal systems, advocate for reform to promote a substantive gender equality. Feminist legal theory can be divided into four schools. Each schools offer a unique lens through which to analyze a legal issue. First, we have a liberal feminism, which seek equal treatment and opportunities for women within existing legal framework through principles of formal equality. Next, we have a cultural feminism that celebrate a feminine value and experience as distinct from a masculine one, advocate for their incorporations into a legal reasoning. And we have radical feminisms, which view patriarchy as the root cause of women's operation, calling for a fundamental society and a legal restructuring. One of the prominent figure under this school is Catherine McKinnon, that we will talk about later, which the work focus on combating a sexual subordination. And last, we have a postmodern or intersectional feminism, which reject the universal claim about women's experience and highlight diversity among women based on the factor of race, class, and sexuality. So let's see some of the prominent figures who have shaped a feminist legal theory. First, we have Catherine, a controversial figure in a radical feminist legal theory. She focused on a woman exposing and combating the sexual subordination of women. She viewed sexual abuse, harassment, pornography, and prostitution as a practice that institutionalized the subordination and objectifications of women. Her legal theory challenged the distinctions between the public and a private sphere, arguing that the personal is a political that the state is responsible for permitting women's operations in the private sphere. So we have Martha Feynman, a leading feminist legal scholar who developed a vulnerability theory as an alternative to the autonomous liberal subject. So she critiqued how current legal and societal framework wrongly assumes and privilege and idealize autonomous individuals unencumbered by constraint. So she argued this autonomy myth ignores that human beings are inherently vulnerable, embodied and interdependent throughout the life course. So she advocated for conceptions of state responsibility, equality, and non-discrimination focus on address vulnerability rather than reinforcing flawed autonomy assumption. So her work challenged feminist legal theory to move beyond sameness or difference debate and the public or private divine. She also proposed replacing the masculine or feminine binary with a vulnerability analysis that recognize constant biological, economic, institutional constraints on autonomy. So her theories underscore the importance of address sociality create the vulnerabilities. Examples: race, gender, poverty in the legal framework. So we have Carol Gilligan. She challenged the male bias in a Lawrence Kohlberg theory of moral development, which privileged masculine value like abstract rules and individualisms. So in her book, In a Different Voice, she proposed an ethic of care as an alternative feminine approach to a morality based on the value like empathy, compassion, and a contextual thinking. So her work highlighted how the law focuses on abstract right and adversarials, processes neglige the feminine perspective centered on relationship and caring. So this influenced the feminist critique of law around issues like reproductive right, family, and the devaluation of caregiving work. So next, we will talk about the contributions of feminism legal theory. So in context of analyze a law through a gender lens, feminism scholar have examined how legal concepts like objectively, naturally, rationally, and privacy are gendered and reflect male experiences. So they critique the public and private distinctions that confine women issues to the private sphere. So the area that they study include the family law, reproductions, right, violence against women, employment discrimination, and the legal constructions of gender. Next, in the view of centering women experience, a major contribution has been evaluating and validating women's life experience as a valid source of legal knowledge. So feminist jurisprudence has highlighted how the law often failed to recognize or adequately address harm and injustice disproportionately affecting women. So it has advocated for a legal reform that consider the realities and interests of women in areas like sexual assault, and domestic violence, workplace discriminations, and reproductive rights. So what are the impact of a feminist legal theory? So in the case of gender equality legislation and policy, feminist legal advocacy has influenced law prohibiting discrimination, sexual harassment, domestic violence, and marital rape. It has shaped policies around issues like pay equity, family leave, child care, and reproductive health service. International treaty and convention like CEDAW reflect feminist effort to ensure gender equality and principles in law. So in the judicial interpretations, feminist legal perspective has impacted judicial reasonings in case involving gender issue like workplace discrimination, same-sex marriage, abortion right, and gender-based violence. So some courts have incorporated the feminist concept like intersectionality, male bias, and the public-private distinctions into their analysis. However, the judiciary still face criticisms for failure to fully adopt feminist approach to achieve a substantive equality. Overall, feminist legal theory represents a powerful critique of gender bias inherent in a traditional legal frameworks, advocate for transformative change to law and the legal institutions to better reflect the realities and protect the right of women across diverse background and experience. Thank you.
Hi, my name is Jusmi Shahnas and I'll be presenting on law and economics. Law and economics is a method that uses the ideas from economics to look at and understand legal systems and rules. It studies how laws can be made to create incentives for people and organizations by making sure that resources are used in the best possible way to benefit a society. This approach believes that legal rules should aim to use resources efficiently to get the best results for everyone. Richard Posner and Guido Calabresi are key figures in this field. Posner, who is a former judge, he emphasized the importance of economic efficiency in legal decisions. As for Calabresi, who is a law professor, he applied economic analysis to accident law, examining the costs and benefits of different legal rules. This approach helps us to understand law by evaluating legal rules through economic efficiency and cost-benefit analysis. It assesses the impact of laws on behavior and the economy, offering insights into how laws can be crafted for optimal outcomes. Law and economics analyze legal rules based on their economic efficiency. This involves assessing whether a law's benefits outweigh its costs. For example, in tort law, it examines how liability rules can minimize the total cost of accidents and precautions. Economic theories are applied to various legal issues to understand their impact. In antitrust law, economic principles evaluate the effects of business practices on competition and consumer welfare. As for property law, they help to understand the allocation and use of resources. This approach has greatly influenced antitrust, corporate and property law by promoting rules that enhance the economic efficiency. In antitrust law, it prevents monopolies and promotes fair competition. In corporate law, it helps companies to operate effectively. As for property law, it ensures efficient use and transfer of property rights. Judges now often consider the economic impact of their decisions, leading to more consistent and predictable legal interpretation. This helps support economic growth and benefits society. By using economic reasoning, judges create a legal system that resolves disputes fairly and promotes overall societal welfare. In summary, law and economics integrates economic principles into legal analysis to promote efficiency and cost effectiveness by reshaping our understanding of law's role in society and judiciary. That's all from me. Thank you.